On a Saturday morning in August, my daughter-in-law had my bed moved to the yard and my belongings directed to the basement, and I stood in the doorway of the room that had been mine for 11 years and watched this happen with the specific quality of attention I bring to events that I have been expecting and for which I have made preparation. The preparation had been in place since 2019. What I was watching in August was the event the preparation had been designed to address. Noelle said, directing the two men she had hired for the furniture moving. The bed goes out to the yard for disposal. The boxes go to the basement storage. Mrs. Pemberton can use the basement space. It'll give her peace and quiet away from the household activity. She said it with the specific efficiency of a woman who has organized things and who wants the organizing to proceed without discussion. I said, "The bed is mine. I'd like it kept." "It's old," Noelle said. "It smells of—" She paused in the way of someone who has decided to say something unkind and who is confirming, briefly, that she intends to say it. "It smells of old people. I'm having the villa properly furnished, and I don't want that smell in the house. You'll be comfortable in the basement. It's cooler than the upper floors in August." "I see," I said. "The new furniture arrives at noon," she said. "I need the room cleared." I went to the bedroom, and I removed my personal items, the things that are mine in the most immediate sense. The photographs on the dresser, immediate personal space of a life. I put these in a bag. I went to the kitchen and I made myself coffee. I sat at the kitchen table and I drank the coffee while the men moved the bed to the yard and my boxes to the basement, and while the morning's work proceeded around me. The bed, which had been mine since 1981, was deposited on the yard's grass near the garden gate. The two men were not unkind about the depositing. They were doing the job they had been hired to do, and the job was not their assessment. The bed's frame was mahogany, which Noelle had not looked at closely enough to notice, and the frame was in good condition. It had been my bed for 44 years. It had been the bed I shared with my husband Wei for 31 of those years, until he died in 2012. I looked at the bed from the kitchen window while I finished my coffee. Then I called Marcus Chen. Marcus Chen is my attorney. He has been my attorney since 1988, which is 37 years, and he practices real estate and estate law from an office in the city, and he is the person who drafted the specific clause in the house's deed that I am going to tell you about. My name is Harriet Louise Pemberton Fong. I'm 75 years old. The house, the villa, as Noelle calls it, which is not the word I would use for a 4-bedroom house in a suburb of Portland, Oregon, though I understand why she uses it, is mine. I paid for it in 1991, when Ways and my finances made the purchase possible, and I have maintained it since, and the deed is in my name, and the specific clause that Marcus drafted in 2019 is part of the deed. The clause was needed. The clause was needed. The Saturday in August told me so. The house at 847 Wisteria Court in the Eastmore neighborhood of Portland is a 4-bedroom, 2-bathroom house with a finished basement, a garden, and the 2 large oak trees in the front yard that I have been aware of for 34 years of ownership, and that I consider among the house's most significant features. The house was built in 1962, and it has the specific quality of houses built in that decade by people who were building for families. The portions are correct. The rooms are arranged for life, rather than for the showcase. The kitchen was designed for a person who cooked rather than for a person who took photographs of cooking. I had bought it in 1991 when Oliver was 11 and May was 8. My children, who are now adults with lives elsewhere, who had grown up in this house, and who carry it as the foundation of what they mean when they say home. Wei had been alive and well in 1991, and the purchase had been a joint decision. though the financing was primarily mine because my career had, by 1991, produced the income that made the purchase straightforward. I was a city planner for 32 years, working for the city of Portland from 1979 to 2011. The work was the work of someone who thinks about how spaces function, how neighborhoods and infrastructure and the arrangement of residential and commercial and public space produce or fail to produce the quality of life that people need. The house at Wisteria Court was, in a sense, a case study in what I believed residential space should be. Modest in pretension, serious in quality, designed for the life lived rather than the life displayed. Noelle had been calling it the villa since she moved in with my son Marcus in 2021. Marcus, not Marcus Chen, my attorney, but my son. Marcus Wei Fong, 39 years old, who is in some respects his father's son and in others a different configuration, had come back to Portland in 2021 from a period of living in Vancouver, and he had come with Noelle, and they had come to the house because the house was large enough to accommodate 3 people, and because my arthritis had made certain aspects of the house's management more difficult than they had previously been. The house's management had included across 34 years the maintenance of a specific way of living that Wei and I had established together, and that I had continued after his death. The kitchen was organized for cooking. The good knives on the magnetic strip, the cast iron on the lower shelf, the herbs in the window box I have maintained since 1993. The bedrooms were rooms for sleeping and for the personal space that bedrooms serve. Not for storage, not for display, not for guest suites. The garden was organized around the plants that had been in it long enough to have established themselves and to require the specific knowledge of a gardener who knows them individually. The climbing hydrangea on the south fence, the heritage apple. In the corner, the vegetable beds I have maintained each year since 2001. Noelle had described the kitchen as cluttered in her second week of residence. She had described the garden as overgrown in her first month. She had described the house, to her friends on the phone, as needing a complete refresh, which I had heard through the specific acoustics of a house, in which voices carry from the living room to the study when the doors are open and the person speaking does not know the other person is present. I had noted these assessments without responding to them immediately, which is the habit of someone who knows that early response to early provocations closes the conversational space before the full picture is available. I had continued cooking in the kitchen, gardening in the garden, and sleeping in my bedroom, and I had watched what the house was becoming in the eyes of the woman who had moved into it. This had been a genuine motivation on my part. The arthritis was real, and the management difficulty was real. What I had not anticipated in 2021 was the speed with which we're here to help you manage the house would become. The house is a villa that needs proper furnishing, and your bedroom would be better as a guest suite, and the Saturday in August suite, and the Saturday in August. When the bed went to the yard, I had not anticipated this without preparation, which is the relevant point. I had begun thinking about the house's legal structure in 2019, 2 years before Marcus and Noelle moved in, when my arthritis had first made me consider what the house's future might look like, and when I had had a conversation with Marcus about the possibility of his returning to Portland. The conversation had been productive in the way that honest conversations about future arrangements are productive. It had produced information. The information, specifically, had been that Marcus and Noelle were interested in the house in a way that was not only about helping me manage it. The interest was not aggressive. It was the ordinary interest of an adult child and his partner who see a valuable property and who have ideas about what that property could be. The ideas were not mean-spirited. They were simply directed by their interests rather than mine. I had called Marcus Chen the day after the conversation with my son. I want to explain the clause precisely before I tell you what it did, because the clause is the technical center of the story and because its precision is what made it effective. The house is my property. The deed, which is the legal instrument that establishes ownership, is in my name. A deed can contain conditions and covenants that restrict or qualify the ownership in specific ways, and these conditions and covenants are legally enforceable if they are properly drafted and properly recorded. Marcus Chen had been practicing real estate law for 31 years when I called him in 2019, and he had seen most of the configurations that property ownership disputes can produce. He listened to what I told him about the conversation with my son and about my concerns, and he asked questions in the specific way of an attorney who is determining not just what the client wants, but what the client's situation actually requires. He asked about the arthritis and about my current ability to manage the house, about what my intentions were for the house in the long term, about whether I planned to transfer ownership to my children, and if so, when and under what conditions. I told him I intended to stay in the house for as long as I was able to manage it, that I was considering allowing my son to live there to assist with management, but that I was uncertain about the conditions under which that arrangement would function, and that I wanted the legal structure of the house to protect my ability to remain in it as the owner, while also making provision for what happened to it after my death, or if I could no longer maintain it. He said, "There are several instruments we could use. A life estate would reserve your right to occupy the property for your lifetime. A deed restriction could condition any future transfer on specific requirements. A conditional ownership clause could specify that certain conditions, if not met, trigger a change in the ownership or management of the property." "Tell me about the conditional clause," I said. He had drafted the clause across 2 weeks, with 2 revision sessions in which I read the drafts and offered comments, and he revised. The clause that was ultimately incorporated into the deed reads in its operative provision as follows: "The continued occupation of the property at 847 Wisteria Court, Portland, Oregon, by any person other than the owner of record is conditioned upon the provision to the owner of record of basic living conditions, as defined herein, within the property." Basic living conditions for the purposes of this clause include the following: private sleeping quarters on an above-grade level of the property, access to shared kitchen and bathroom facilities on the same level as the sleeping quarters or by stair access without exterior travel, and freedom from conditions of habitation that a reasonable person would find degrading or uninhabitable. In the event that these conditions are not provided, the owner of record may, upon documentation of the failure of these conditions, require the immediate vacation of the property by any non-owner occupant with 30 days' notice. If the owner is unable or unwilling to exercise this right, the ownership of the property shall transfer to the Cascadia Community Housing Foundation, a registered Oregon nonprofit, to be used for affordable housing purposes consistent with the TO Foundation's stated mission. The clause was specific, and it was drafted with the precision of someone who had been doing this for 31 years. The above-grade level requirement meant that a basement was not a qualifying sleeping space. The reasonable person standard for degrading conditions was the legal standard for habitability, which Marcus Chen could argue in any Oregon court without difficulty. The transfer to the Cascadia Community Housing Foundation was the specific consequence that gave the clause its teeth. It was not a transfer to my children or to anyone who might be expected to reverse course under pressure. It was a transfer to a charitable organization whose mission would be served by the property's use for affordable housing. The Cascadia Community Housing Foundation was not chosen randomly. I had been on the Foundation's advisory committee from 2008 to 2014, during the years when Portland's affordable housing crisis was beginning its acute phase, and I knew the Foundation's work from the inside. They were a well-run organization with a clear mission and the legal capacity to receive and manage a property of the house's type. If the clause were ever triggered, and if I did not exercise my right to require vacation, if, for instance, I were incapacitated and unable to exercise the right, the property would go to an organization that would use it for a purpose consistent with what I had spent 32 years working toward as a city planner. This was the secondary elegance of the clause, which I did not describe to Noel in the kitchen confrontation, because the confrontation was not the right context for secondary elegances. The clause was not only a mechanism to protect my occupancy, it was a mechanism that, if my occupancy could not be protected, would ensure that the property served the public good. Either I lived in my house under conditions appropriate to its owner, or a charitable organization used the property for affordable housing. In no configuration did the clause allow the property to be converted into a showroom for Noel's furnishing program. The clause had been recorded with the deed in 2019. Noel did not know about it. My son Marcus knew about it, I had told him in a separate conversation after the recording, because he was an adult and he deserved to know. He had received the information with the specific quality of someone who is absorbing something that changes the shape of a situation without immediately knowing how to respond. He had not told Noel. I want to tell you about Noel honestly, because the honest account of a person is more useful than either the sympathetic version or the unsympathetic version. Noel Marchetti Fong is 36 years old. She came from a family in Vancouver whose approach to wealth was the approach of people who had it recently, and who were still in the process of establishing the relationship between their current circumstances and who they were. Her mother and father had built a contracting business in the 1990s that had done well in Vancouver's real estate market, and Noel had grown up in a household where the visible markers of success, the house, the car, the vacation, quality of vacation, the quality of the furniture, were the primary language of security and status. This is not unusual. Many people speak this language, and it is a language with real content. What is less common is the translation of the language into the specific management of another person's space. The decision that the house at Wisteria Court required proper furnishing was Noel's translation of the security language into a program. For the house and the program was organized around what the house should look like to visitors rather than what it should feel like to the person who lived in it. I am the person who lives in it. My comfort and my belongings and my 44-year-old bed are the substance of the house for me. For Noel, they were the material of a space that needed to be made presentable. She had arrived in 2021 with the warmth of a young woman who is pleased to be liked and who directs considerable energy toward the project of being liked. She had cooked dinners and asked questions about my life and helped carry groceries and generally performed the role of a good daughter-in-law with the specific competence of someone who understands roles and who plays them correctly. The warmth had not been false exactly, but it had been in the service of a project that I had understood fairly quickly. As the months passed and as the conversations about the house's furnishing and arrangement had accumulated, the project was the transformation of the house from my house into a house that Noel could present as reflecting her standards. My son Marcus was not the driver of this project. He was its recipient, the person who was being moved along by it in the way that people who love their partners and who are not paying close attention to the direction of movement are moved. The 3 years had proceeded through several stages. The first stage was the arrival and the warmth and the genuine helpfulness. The second stage was the incremental rearrangement. Furniture moved, objects relocated, the kitchen reorganized according to a different logic from the one I had been using since 1991. These reorganizations were presented as improvements, and I had, in many cases, accepted them as improvements, because the acceptance was easier than the resistance, and because the changes were not in themselves worth the friction. The garden beds in the second summer, a moment I return to when I think about the accumulation, were the first unambiguous indication. Noel had hired a landscaping company to tidy the garden without discussing it with me, and the company had, with the efficiency of a professional crew acting on a client's instructions, removed the plants that had looked untidy to someone who did not know what they were. Among the removed plants was the climbing hydrangea on the south fence that I had planted in 1999, and that had taken 4 years to establish. It was, to someone who did not know it, a woody vine that needed pruning. To me, it was a 22-year-old plant in its prime. I had said something about the hydrangea. The something I had said was clear and direct. The garden was mine, and the plants were mine, and decisions about them required my participation. Noel had said she was sorry and that she had not realized, and that it would not happen again. It had not happened again with a specific plant. What had happened instead was the general approach had become less direct. The space of the house was managed in incrementally smaller ways that individually were below the threshold of confrontation, but that cumulatively were transforming the house. From the house I had built to the house Noel was building. The third stage was the furnishing program. Noel's decision, announced in the spring before the August Saturday, that the villa required proper furniture and that the existing furniture, including my bed, was insufficient. She had presented this to Marcus as a home improvement project and to me as an upgrade that I would surely appreciate. I had said I was comfortable with the existing furniture and that I preferred it to remain. She had said she understood, but that the renovation would proceed regardless. The August Saturday was the third stage, reaching its conclusion. What Noel had not known on the August Saturday was that the third stage had also reached the clause's trigger. 32 years as a city planner in Portland produced in me a specific understanding of how physical spaces and legal structures interact, how the rules that govern what can be built where and how it can be used produce the physical environment that people live in, and how the physical environment shapes the lives of the people who inhabit it. City planning is not primarily about aesthetics, though aesthetics matter. It is primarily about function. How do the spaces that a city contains serve or fail to serve the people who need to use them? The zoning code, the building requirements, the infrastructure standards. These are the legal structures that produce the physical structures, and the physical structures produce the conditions of life for the people who occupy them. I came to city planning through architecture. I had done 2 years of an architecture degree at the University of Oregon before concluding that the work I wanted to do was at the scale of the city rather than the scale of the building. And I had transferred to the urban planning program and completed the degree that led to the position at the City of Portland. The 32 years of work there had been, in the aggregate, the work of someone who was trying to understand and shape the conditions of life for the people of a specific city. This understanding, the understanding of how physical conditions produce lived experience and how legal structures shape physical conditions, is the understanding that produced the clause. The clause was not simply a legal instrument. It was a planning instrument, a mechanism for ensuring that the physical conditions of a specific space met the standard required for the dignified habitation of the person for whom the space existed. Basic living conditions as a legal standard has a long history in housing law. The habitability standard in landlord-tenant law, the building code requirements for residential space, the fair housing standards that prohibit certain conditions of occupation. These are all expressions of the same underlying principle. People who occupy residential space are entitled to conditions that a reasonable person would find acceptable. The clause in the deed was an application of this principle to the specific situation of an owner who was at risk of having her own property's conditions of occupation deteriorated by other occupants. I had spent 32 years applying habitability standards to the housing of other people. The clause applied them to my own. The planning work had also taught me something about the relationship between preparation and outcome, in situations where power relationships are contested. In planning, the most effective regulatory instruments are not the ones that are most frequently invoked, but the ones that are most specifically calibrated to the situations they are designed to address. A rule that is too vague is unenforceable. A rule that is too specific fails to address the situations that don't fit the specific case. The well-drafted rule, the rule that is specific enough to be applicable and general enough to be flexible, is the one that produces its intended outcome when the outcome is needed. Marcus Chen and I had spent 2 weeks drafting the clause because 2 weeks was what it took to make the clause well drafted. The work had been the same work I had done across 32 years of planning practice, figuring out exactly what the rule needed to say to achieve the outcome the situation required. The outcome the situation required was, I should not be able to be moved to a basement. The August Saturday demonstrated that the outcome had been correctly anticipated. Marcus Chen answered his phone on a Saturday morning because he is a man who has been practicing law for 37 years and who understands that certain calls from certain clients are worth answering on a Saturday morning. I am one of those clients, not because I call frequently on Saturdays. I do not but because he has known me long enough to understand that when I call it is because something has happened. I told him what had happened. He listened in the specific way he listens, completely, without interrupting, with the occasional sound that indicates he is present rather than waiting. When I finished, he said, "The bed is out of the house." "In the yard," I said. "The men who moved it will come back for it. I expect Noel intends to have it taken to disposal." "And your sleeping quarters," he said. "The basement," I said. "Below grade." "The basement was used for storage until recently. It has a concrete floor and 2 small windows at grade level." "That's a clear trigger," he said. "The above grade level requirement is met or not." "A basement with a concrete floor and grade level windows is below grade." "Yes," I said. "That's my assessment as well. What do you want to do?" he said. "I want the clause enforced," I said. "I want the non-owner occupants required to vacate. I want the house returned to the conditions appropriate for the owner." "I'll need to document the conditions," he said, "before anything changes. Can you take photographs of the basement as it currently exists and of the bed in the yard? Date and time stamped if possible." I took the photographs. I sent them to Marcus Chen. I took the photographs in the morning while the bed was still in the yard, and while the basement was still empty of everything except the storage it had previously contained, and the single cot that Noel's men had placed there for me. The cot was worth photographing. A cot in a basement concrete space is a specific image, and the image is legible to anyone who looks at it. Marcus Chen called me back at 11:30. He said, "I'm going to prepare the documentation for the eviction notice. I need to retain a housing inspector to evaluate the basement space against the clause's habitability language. The inspection can be done on Monday. I'll file the notice Tuesday. Is there anything I should do in the meantime?" I said. "Stay in the house," he said. "Don't move into the basement. If Noel or Marcus direct you to the basement, tell them your attorney has advised you to remain on the above grade level, pending a legal review of the housing conditions. If they object, call me immediately." "Understood," I said. "Harriet," he said, "this is going to produce a significant conflict with your son." "Yes," I said. "I know. Are you prepared for that?" "I've been prepared for it since 2019, I said. I stayed in the house for the weekend. I slept in the living room, on the sofa, which is above grade and which is a reasonable temporary sleeping arrangement for a 75-year-old woman with arthritis, who is not in the basement. Noel had looked at me sleeping on the sofa on Saturday evening with the expression of someone who has arranged a situation, and who is finding that the arrangement is not proceeding as planned. She said, "The basement is more comfortable than the couch. There's a cot. My attorney has advised me to remain on the above grade level of the property, pending a legal review of the housing conditions," I said. "I will be on the sofa until the review is complete." The mention of my attorney produced the specific quality of silence that the mention of an attorney produces in a situation where someone was not expecting an attorney to be mentioned. Noel looked at me for a moment and then went to find Marcus. Marcus came into the living room. He is my son, and I have known him for 39 years, and I could see in the way he came into the room that he was in the uncomfortable position of someone who is about to have a conversation he did not anticipate having, and who has not yet determined how to have it. "Mom," he said, "you mentioned a legal review." "Yes," I said. "My attorney is having the basement space evaluated for compliance with the conditions in the deed." "The deed," he said. "The clause." "Yes," I said. He sat in the chair across from the sofa. He looked at me in the way he looks at me when he is genuinely thinking rather than managing the conversation. "I told Noel about the clause when we moved in," he said. "This was not what I had expected." "You did?" I said. "She didn't take it seriously," he said. "She said it was a liability lawyer's overreach, and that you'd never enforce it against your own son." "She was wrong on both counts," I said. "Marcus Chen is a real estate attorney, and the clause is precisely drafted. And the clause is not directed at you. It's directed at the conditions of the house. The conditions are what they are, regardless of who created them." He was quiet. "She put your mother in the basement," I said, "on a cot, in a concrete room. and move the bed I've had for 44 years to the yard to be disposed of. He looked at the window. Outside the window was the yard, where the bed was still sitting near the garden gate. "I know," he said. "You showed me last week," he said. "That the room would be a guest suite, that you'd have your own space in the basement." I said. He looked at the floor. He is 39 years old, and I am his mother, and the specific kind of discomfort that this moment produced in him is visible in a way that it is only visible when you have known someone for 39 years. "I should have said something," he said. "I didn't. That's mine to account for." "Yes, it is. It is." I thought about Way on the Sunday, sitting in the living room on the sofa where I had slept, with the morning light coming through the windows and the oak trees visible in the front yard. I think about Way most days. This is not unusual for someone who was married for 31 years and who has been a widow for 13. But on the Sunday, I thought about him in this specific way. That is not nostalgia, but consultation. About what someone who knew you completely would say about the situation you are in. Wei Fong had been an engineer, structural engineering specifically, which is the engineering of how things hold weight. He had spent his career understanding the relationship between load and support, between the forces that bear down on a structure and the structures designed to bear those forces. He had approached most of the problems of his life in engineering terms. What are the loads? What are the supports? What happens when the loads exceed the design capacity? He'd been the kind of engineer who explains his work to non-engineers, not by simplifying it, but by finding the right analogy. He had said to me once about a bridge project he was working on, "The failure mode that most engineers worry about is overload, putting more weight on it than it was designed for. The failure mode that actually kills people is incremental degradation. The slow rusting, the small cracks that were always there and grew slightly larger each year. You don't notice until you notice all at once." I had thought about this explanation many times in the years since, in contexts far from bridge engineering. The 3 years of Noel's incremental rearrangements were the slow rusting. The August Saturday was noticing all at once. He had been in his personal relationships a man who distinguished carefully between the people he could trust to bear weight and the people who couldn't. Not unkindly, he was not a person who classified people as failures, but he was honest about load-bearing capacity, and the honesty produced his decisions about where he invested trust. He had not known Noel. He had died in 2012 when Marcus was 26 and unmarried. But I thought, on the Sunday morning, about what he would have said about the bed in the yard and the cot in the basement. He would have said, "Harriet, the bed is the thing that tells you what the structure is. A structure that puts the owner's bed in the yard has decided what the owner is. The clause is correct. Use it." He would have said it in this specific way. He said things that were obvious to him and that he suspected I already knew. As confirmation rather than instruction. I had already known. The clause had been in place for 4 years. The bed in the yard had confirmed what the clause was for. I also thought, on the Sunday, about what the house meant to Way. He had not bought it. I had, with my city planner's salary in a year when the Portland real estate market made the purchase possible. But he had lived in it from 1991 until his death in 2012. And he had put his work into it the way structural engineers put their work into things. Carefully, with attention to what would hold and what needed reinforcing. He had rebuilt the back deck when it needed it. He had reinforced the foundation drainage when the basement showed moisture. He had been attentive to the house in the way of someone who respects the structure he inhabits. The basement he had reinforced against moisture was the space Noel had assigned me as sleeping quarters. He would have found this specific irony legible. I found it legible too. The housing inspector Marcus Chen retained was a woman named Diane Okafor, who had been doing residential inspections in the Portland area for 17 years, and who brought to the basement on Monday morning the specific professional attention of someone who has evaluated habitable space under legal standards many times and who knows what the standards require. She spent 40 minutes in the basement. She measured the ceiling height, 7 feet 2 inches, which is adequate but is the minimum. She evaluated the windows, 2 windows, each approximately 12 inches by 18 inches, at grade level, providing limited natural light and limited ventilation. She assessed the moisture conditions. The basement was dry, which reflected waste drainage reinforcement, but it had the specific quality of below-grade air that below-grade spaces have. She noted the concrete floor and the absence of finished walls or ceiling. She produced a report that afternoon. The report addressed the clause's specific requirements. On above-grade level sleeping quarters, the basement was below grade. The requirement was not met. On access to shared kitchen and bathroom facilities, the access from the basement to the kitchen required passing through the utility room and ascending 12 steps. The access was functional, but would be difficult for a person with significant arthritis. The requirement was marginal, on conditions that a reasonable person would find degrading or uninhabitable. The concrete floor, the limited natural light, the below-grade air quality, and the absence of finished surfaces created conditions that a reasonable person would not find adequate for primary habitation by an elderly person with a diagnosed mobility limitation. The requirement was not met. Marcus Chen filed the notice on Tuesday. The notice was addressed to Marcus Wei Fong and Noel Marchetti Fong as the non-owner occupants of the property, and it stated that the conditions of the deed had been violated and that, pursuant to the clause's provisions, the non-owner occupants were required to vacate the property within 30 days. The notice was served by a process server on Tuesday afternoon. I know when it was served because I was in the kitchen making tea when Marcus came in with the notice in his hand and the expression of someone who has received a document that has made something real that was previously theoretical. He said, "Mom." "Yes," I said. "You filed this," he said. He held the notice toward me. "You actually filed this." "Yes," I said. The clause specifies that the conditions trigger the notice. The conditions were met on Saturday. I filed the notice on Tuesday. 30 days, he said. 30 days, I said. I want to be clear about something, Marcus. The notice is to both of you. But the decision to move my bed to the yard and my belongings to the basement was Noel's. You told me you knew about the clause and that you didn't object to the renovation plan. What I'm asking you to understand is that the clause exists because the situation that triggered it was foreseeable, and the situation was foreseeable because you were already the person who had allowed Noel's plan to proceed over my stated objections. He looked at the notice. I'm not choosing her over you, he said. I know, I said. I'm not asking you to choose. I'm asking you to understand that the choice was made by the combination of actions taken over 3 years, and that the clause's consequence is the consequence I put in place for exactly those actions. Noelle came into the kitchen 20 minutes after Marcus. She had the notice in her hand and the expression of someone who has moved from surprise through anger and has arrived at confrontation. This is a legal action, she said. You're evicting us from our home. This is the enforcement of a condition in the deed of a house that is mine, I said. The clause specifies that non-owner occupants are required to vacate if the owner is not provided with basic living conditions. The basic living conditions clause was triggered when you moved my bed to the yard and directed me to the basement. The basement is a perfectly adequate space, she said. I've seen people housing inspector's report assesses the basement as failing to meet the clause's habitability standard for a person of my age and condition, I said. The report is attached to the notice. She was holding the notice. She looked at it. She looked at me. You planned this, she said. The clause has been in the deed since 2019, I said. Since before you moved in? Marcus knew about it. I told him when it was drafted. She turned to Marcus. You knew about this? You knew about this clause and you didn't tell me. The specific quality of this moment. The moment in which the confrontation between Noelle and me became also a confrontation between Noelle and Marcus was not something I had planned. I had not planned it because I had not known until Saturday evening that Marcus had told Noelle about the clause when they moved in. His telling her and her dismissal of it as liability lawyers' overreach was information I had not had. The information changed the shape of the situation. Noelle had known about the clause. She had dismissed it. She had proceeded with the renovation plan in full knowledge that a legal mechanism existed to reverse its consequences for me. The proceeding in full knowledge was a different act from proceeding in ignorance. I did not say any of this to Noelle in the kitchen. I am not a person who uses the information I have at the moment I acquire it, which is a quality that city planning work builds over 3 decades. You gather the information, you analyze it, you determine how it changes the picture, and then you decide how to act. What I said was, I have lived in this house since 1991. I bought it and maintained it and expected to continue living in it with appropriate conditions. The clause exists to ensure those conditions. The clause exists to ensure those conditions. I'm sorry for the disruption to your arrangements, but the enforcement of the clause is what it is. Noelle looked at me for a long moment. Then she looked at Marcus. Then she left the kitchen. Marcus sat at the table. He looked very tired in the specific way of someone who has been carrying something for a long time and who has run out of the energy that the carrying required. I should have stopped it, he said. The renovation. The bed. I should have stopped it. Yes, I said. I didn't. No, I said. You didn't. What do we do? He said. You have 30 days, I said. I would like to give you the 30 days. I would like, at the end of 30 days, to sleep in my bedroom. In my bed, which I expect you to retrieve from wherever it has been taken. I would like the house to return to being a house in which I am the owner, and in which I am treated as the owner. Beyond the 30 days, what you and Noelle do is your decision. The 30 days were not simple. I want to say this honestly, rather than presenting the outcome as easier than it was. Noelle spent the first 10 days managing her response to the notice, which meant a conversation with her own attorney, a consultation that I expected, and that was appropriate, and a period of resistance that was the resistance of someone who has not accepted that the situation is as it is. Her attorney apparently confirmed what Marcus Chen had told her. The clause was properly drafted, the trigger had been met, the notice was legally enforceable, and the consequence of not vacating was the transfer of the property to the Cascadia Community Housing Foundation, which would make their occupancy impossible in any case. The transfer provision was what produced the acceptance. Contesting the notice might have bought time, but the contestation would have been on a record that showed a concrete floored basement, a cot, a 44-year-old bed in the yard, and a housing inspector's report. The record was not in Noelle's favor. She found an apartment in the second week. It is a 2-bedroom apartment in a building in Northeast Portland, which is an area I know well from the city planning years, and which is a good neighborhood with good buildings. The apartment is smaller than the house at Wisteria Court and has no yard, which I understand is a real adjustment. Marcus was more complicated. The 30 days produced several conversations, some of which were the hard conversations that needed to be had, and that the 3 years of Noelle's renovation project had deferred. He came to the house on a Thursday evening in the 3rd week, without Noelle, and we sat at the kitchen table and talked for 2 hours about the 3 years, and about what had happened, and about what the clause represented. He said, "The clause it's humiliating in a way. that my mother needed to put a legal mechanism in place to protect herself from the possibility that her son's household would put her in a basement. "Yes," I said. "It is." "I should be humiliated," he said. "You should understand what happened," I said. "The humiliation is secondary. What matters is whether you understand the pattern, the 3 years of incremental displacement, the villa that wasn't yours to name, the renovation that wasn't yours to plan, the bed that wasn't yours to dispose of. The humiliation is the acknowledgement that the pattern was real. The understanding is what you do next." "I love her," he said. "I know," I said. "And the loving her and the 3 years of not seeing are connected in the way that love and not seeing are often connected. I'm not asking you to not love her. I'm asking you to see clearly what happened in this house." He came back twice more in the 30 days. Both times were better than the Thursday conversation, in the way that conversations get better when the initial difficulty has been navigated, and when the person you are talking to is genuinely trying to understand rather than manage. The bed was retrieved from a storage facility where Noelle had had it taken when the yard was tidied. The retrieval required Marcus hiring a small moving crew and was accomplished the day before they vacated. The bed came back to my bedroom. I slept in it on the night of the 31st day. It is October.A. The house at 847 Wisteria Court is as it has been since the 31st day of the notice period. Mine, in the full and uncontested sense of mine, occupied by one person who is 75 years old and who has been the owner for 34 years and who intends to remain so. The bed is in the bedroom. The bedroom is mine. The oak trees in the front yard have turned, as they turn every October, to the specific gold of Portland autumn, which is the gold I have watched from these windows for 34 years, and which I find each year newly satisfying in the way that the familiar things we have chosen to live with are satisfying when they do exactly what they always do. Marcus comes for dinner on alternate Sundays. He has been in the apartment with Noelle since the 30 days ended, and the apartment, from what he describes, is functional and appropriate and different from the house in ways that are both difficult and clarifying. I have not formed a firm view on whether the relationship will continue or not. That is his situation and his to navigate. The clause remains in the deed. It has served its purpose once, and it remains in place because the purpose it serves is the purpose of the deed's condition of occupation. And the condition does not expire because it was once exercised. If the house is ever occupied by other people again, the clause will apply. What do I know at 75? After 34 years in this house, and the 3 years of Noelle's renovation project, and the August Saturday, and the 30 days of the notice. I know that a house is not simply property. A house is the physical expression of a life. The accumulated decisions about how a space should be used, what it should contain, how its rooms should be arranged for the people who live in them. My house has been the expression of my life, and Way's life, and the children's lives for 34 years, and the expression is specific and irreplaceable in the way that all expressions of a specific life are specific and irreplaceable. I know that preparation made in advance of need is the most effective kind. The clause was drafted 4 years before the August Saturday. The drafting required me to anticipate a situation that was then only a possibility, and to address it precisely before it was a reality. City planning taught me this. The most effective regulatory instruments are the ones that exist before the situations they are designed to address. A rule drafted in response to a crisis is almost always inadequate. A rule drafted in anticipation of a foreseeable situation is almost always sufficient. I know that the relationship between love and accountability is not a contradiction, but a requirement. I love my son. The enforcement of the clause was an act of accountability that the love required rather than prevented. If I had not enforced the clause, if I had accepted the basement and the cot and the disposition of the bed as things I was powerless to address, I would have communicated to Marcus that the consequences of allowing something to happen to me were manageable. The clause communicated something different. that the consequences were real. That basement was originally for garbage, I said, in one of the dinner conversations with Marcus in the weeks after the notice. I said it lightly, not as a condemnation. And Marcus looked at me, and we both understood the specific thing that was being said. The basement was storage. I was not storage. The clause made this distinction legally precise. The house is a house. It is the house I have lived in since 1991. The bedroom is mine, and the bed is mine, and the oak trees are doing what they do every October. I made tea this morning and sat at the kitchen table with the Oregonian and the crossword, as I have done most mornings for 34 years. The house was quieted in the way that houses are quiet when they contain one person who is at home in them. I was at home. The clause has always been for this, to ensure that I could remain at home in my own house. It worked.